Okay, good morning. It's the Thursday morning legal update. We're a little late. It's 10:33. Again, Facebook is making it difficult to go live and live stream, so we'll post this on Facebook and on LinkedIn. Gonna have to figure another way to do this, maybe through YouTube or some other service. Anyway, I'm Mitch Beinhacker. I'm a business attorney and an estates attorney in Clark, New Jersey. I have a solo practice, work with small business owners, executive professionals, helping them with transactional work and document work. A big part of my practice is a drafting shop. So I draft operating agreements and buy-sell agreements and leases and non-competes, which I spoke about a week and a half ago or so ago. You can find it on YouTube, um, for business owners and executives and different people like that. So today I wanted to talk about, and people ask me these questions all the time, like, when do I need agreements? What kind of agreements do I need as a small business owner when it comes to running my business? So when you form a company, whether it's an LLC or a corporation, let's say, usually an S corporation, you're going to receive, and I don't want people to confuse these two, you're going to receive either a certificate of formation if it's an LLC or articles of incorporation if it's a corporation. Okay. Those articles are just formation papers. So if you need agreements, operating documents that run your business. So with an LLC, limited liability company, it's called an operating agreement. Not surprising. If it's a corporation, um, they're bylaws. With a corporation, in all cases, you should have bylaws. You should have a corporate book, a seal, stock certificates. You should issue those certificates, and you have to keep certain formalities in order to obtain or receive the creditor protection that you get from having a corporation or a limited liability company. That's why it's called a limited liability company. So you set up these companies for a lot of reasons, but one of the main reasons is to get creditor protection from acts of the corporation. So if somebody sues the business, they don't necessarily sue you personally if you're following the rules and regulations. That excludes like fraud. If you commit fraud, you'll be sued personally. But when it comes to having a corporation or an LLC, you need to follow certain formalities, and there's more formalities with a corporation than it is with an LLC, which is why I like LLCs better in most cases. So with a corporation, you got to be following certain rules. You got to have annual meetings. You got to keep books and records. You got to keep separate bank accounts. You got to have issued stock certificates. You got to have bylaws with all the rules that go on. If you get sued, a litigating attorney is going to request all the books and records of the corporation to see if you're actually following those rules. And if you don't, they may be able to reach you personally through the lawsuit. Okay, so it's important that if you set up a corporation or you have a corporation, maybe you've been in business for a long time, look through your records. Make sure you have bylaws and that they're not in plastic. You didn't not open the book. You might have gotten a book with a seal from your lawyer. Make sure that you've printed out stock certificates and you follow those rules on a regular basis. I've been in situations where we're selling a business and I can't either find the bylaws or don't have them. We got to create them, and that's not a position you want to be in. So that's very important with corporations. If you're an LLC, as a lot of small businesses are these days, you may need an operating agreement. Now, an LLC is subject to the rules and regulations that it creates. So it creates its own rules based on an operating agreement. If it's your own business, so you're a solopreneur, you're the only person that owns the LLC. You don't even have a business tax return because it goes on your Schedule C as a sole proprietor, which is what happens with one-person LLCs from a tax standpoint. You may not need an operating agreement to set up the rules that affect your business. You're the only person. Doesn't make any sense. But there may be some situations where you do need an operating agreement. You're getting a business loan or you need to open a business account. Depends on the bank. Usually you can get around that when opening your business account if it's just you. But if you have a partner, if you have more than one partner, you're going to definitely want an operating agreement that lays out the rules and regulations of running the business. What can the manager, the person who runs the day-to-day operations of the business, do on a regular basis without your involvement? What things do you need to vote on where everyone needs to agree? What happens if the business gets sued, or what happens from when filing taxes or keeping books and records? What happens if there's a dispute between the partners and all those types of stuff? That should all be in an operating agreement. And as a matter of fact, you can get a basic operating agreement, basic bylaws from my website at a discount if you go to beineckerlaw.com and click on the automated services tab of the menu bar. You can choose that. You'll also get it in Word format, so you can make some changes to the rights and rules and so forth of the parties. So that might be a good place to start to save yourself some money and at least have an agreement. When it comes to other things of the business, so people ask me, like, when do I need other agreements to deal with vendors and customers? The reason that you have agreements, the reason that things are in writing, obviously, are when things fall apart. If everything went fine and everyone agreed and everything was done in a handshake, you wouldn't need a written agreement. And maybe 200 years ago that was the case, and over time there were lawsuits and people would sue each other, and judges were trying to figure things out, and they created different statutes. For example, a statute of frauds that requires in certain contexts that things have to be in writing, or you don't have any rights. So the biggest problem that you run into with a vendor, with a customer, is a misunderstanding or miscommunication or his or her interpretation of your arrangement that's different than what you think it was. So it is very important that you have a client agreement, that you have a vendor agreement, that you put everything in writing, because those agreements are going to have things that deal with how do you resolve a dispute. If there's a lawsuit, what happens? Where is the dispute brought in? What county or what state? You're going to have things that deal with what your remedies are if you don't agree on something. Maybe you go to mediation first. Maybe you go to arbitration. Maybe you go to court. Not a huge fan of arbitration. I haven't had the best results with it, but some people love it. It's a little bit more costly than mediation and sometimes less costly than going to court. But you want to lay out all those rules. You also want things to, the agreement would say that your agreement is within the four corners of this document, and anything you've discussed and discussions you've had orally do not apply to the agreement. It's got to be in writing. It'll also say things like, if you drafted the agreement and you're giving it to your customer or to your vendor, it will say that if there are any ambiguities in the document, meaning you think this clause means one thing and the other person thinks it means another, that a judge won't construe things against you, because generally if you don't have those provisions and things are ambiguous, a judge may tend to rule in favor of the other party who didn't draft the agreement to begin with, who may have not had the negotiating power, the leverage in the agreement. So you want to have those kind of provisions in a document. So that's why I've been in situations where people make private loans, or they invest in a business, or they invest in a real estate project. And a lot of this stuff is done on a handshake, and it's always when things fall apart. That's why you have agreements. If things weren't going to fall apart, you wouldn't need an agreement. Agreement is when you go in front of a judge, you're going in front of a mediator. What was the rules and how are you going to resolve this? And it's going to save you money if that happens. It's going to save you a lot of heartache if that happens. If you're buying commercial real estate, you want to make sure that that you have a contract, which if you're dealing with a lawyer, of course, that would happen. But it says, what's your rights? How much time do you have to do your due diligence? When do you get your deposit back? What happens if you can't agree on things? And all those types of stuff to avoid protracted litigation. That's what contracts are about. You can always breach a contract. It's not illegal. There's no criminal liability from breaching a contract. It's just a question of what damage you're causing to the other party. So if you have a relationship where you loan somebody for their business $100,000 and you had this ongoing relationship, they're paying you every month at interest, and the only thing you have is text messages, emails, maybe recorded phone calls, I don't know, whatever it is, to try and create a contract later on, that becomes seriously problematic for a judge or for attorneys that are trying to negotiate things, because there's going to be a lot of he said, she said. And there's going to be things outside of those emails and text messages that they say, well, what about that conversation we had 2 months ago where you said this? So it becomes very problematic when you don't have things in writing. I even tell homeowners, if they are doing a renovation in their house, and I tell this to the builders too, you have a contract, and that contract generally provides for written change orders. But in the course of the construction, there's discussions about things. Hey, if I adjust this or I change this window, this will be better. Okay, let's do it. And maybe due to lack of, timing and bookkeeping and so forth, you never get a change order to sign because it's all done on the fly. I recommend to homeowners that they keep a binder and that they send an email following up with the discussion. Okay, we talked about this. You're changing this window in the kitchen. You said it's no additional charge. And then later on, if the builder comes back to you and says, no, we didn't discuss this, there's an additional charge for the window, you can say, well, here's the email I sent you on this date. You didn't reply to it. It said that you were doing this at no additional charge, and it's going to be harder for the builder to claim otherwise. But I see a lot of people get in trouble in that regard. So what other agreements do you need? Well, you might need, like I said before, non-disclosure agreements, non-compete agreements, non-circumvent agreements, agreements that prevent employees from stealing clients. A lot of those agreements should be signed at the time that they start working for you. It's hard to do them after the fact without any kind of consideration. Non-disclosure agreements should always be created and signed, obviously, before you start talking to somebody about the idea, about your concept, about your product, about what it is you want to pursue. Leases, obviously, you don't want to rent space without having a lease in writing. You would think if you're renting commercial space, you'd always have a written lease. That's not always the case. Sometimes apartments are rented without formal leases. And if you're a landlord, there's a lot of very stringent rules when you have residential tenants that you need to follow as a landlord, or you are out of luck. You can't get attorney's fees. You can't get late fees. You may not even be entitled to rent. I've seen judges award free rent to tenants who had problems with their apartment and they didn't have anything in writing and the landlord didn't follow the rules. We have some very strict landlord-tenant rules that are very tenant favorable in New Jersey. We have anti-eviction statutes that prevent you from just throwing somebody out of an apartment just because their lease is up. So you got to make sure that you follow that and you keep things in writing and you're, you document things very well. I'm trying to think of what other agreements. So client agreements, buy-sell agreements. So if you have a situation where you have a partner or you have a key employee and you want to set up an arrangement where that employee or that partner takes over the business, what happens to your share if you die, you become disabled, you want to leave the business? That's what a buy-sell agreement's for. And those you definitely want in writing. Sometimes insurance needs to be involved because there's events like someone dying that needs to be funded where there's money to buy out the surviving spouse. So you're not in business now with your partner's wife, surviving spouse, or one of you getting sued or getting divorced. You want to know, well, what happens to the business if that were the case? And there's ways that you can put protections in place with an agreement that's negotiated at arm's length to do that. Now, if it's a family situation, two brothers in a business, arm's length becomes a little bit more difficult, but those are things you can discuss with your lawyer and when you're doing that stuff. So you don't want to do is go out, buy some life insurance, maybe set it up wrong, because there are ways to set up life insurance in a business situation that can make it taxable, believe it or not, and not do it subject to an agreement. So there are a lot of situations where an insurance broker, well-intended, is trying to get insurance in place for the business if someone dies and tells the business owner, listen, you got to get an agreement in place, and the agreement's never put in place. So if you have insurance and you own a business, you don't have anything subject to an agreement, you want to go look into that immediately and get an agreement in place. Maybe part of the insurance is for key person. Maybe part of the insurance is for the buyout. I've been brought into situations after the fact when the partner dies, there's insurance in place and everything's set up wrong. The beneficiaries are wrong. The agreement wasn't executed properly. And now the surviving family is arguing with the remaining partner that the insurance is their family's insurance, for example, and he also owes the money under the agreement, and he's been paying for the insurance, and that was supposed to be used for the agreement. So I've gotten involved in situations where I was able to, in most cases, rescue that. You make an insurance company nervous enough and they won't pay out their proceeds, they'll put it into escrow and you guys can argue about it later, but not the position you want to be in, because then it costs you a lot of legal fees for my time. And it may end up in litigation, which I don't do, but I would bring in a litigator to take it over if we can't settle it, negotiate it. So you want it in writing. So that's the basic rule. When somebody says, well, when do I get it? If you are in a situation where if whatever you're doing, the relationship with the client, the relationship with the vendor, the relationship with your partner, if that goes awry and you don't know what the rules are going to be and you don't have anything set up ahead of time as to what happens, that's when you need something in writing. So I'm going to end it here. If you have any questions, you can always reach me at my website at beinhackerlaw.com or send an email to info@beinhackerlaw.com. You can also listen to my podcast called The Accidental Entrepreneur, where I interview business owners and influencers about entrepreneurship and small business ownership and what you need to do to be successful. Don't be successful or fail by accident. Do it on purpose. So next update will be next Thursday at 10:30. Thanks for joining me, and I will see you all soon.